Hi there. I wanted to comment on a report I read recently on the result of the action against the directors and trustees of the kids company, the action to disqualify them as directors. There was an action particularly against the chief executive, Camila Batmanghelidjh, to disqualify her for 6 years. Other trustees and directors, the official receiver wanted to disqualify them for in some cases 3, some cases 4 years. So I just look at this particular case and the outcome, and then I want to comment generally on the provisions for disqualifying directors. Now, you may recall that Kids Company, or I think the company's Keeping Kids Company Ltd, failed in 2015, went into liquidation with the official receiver acting as liquidator. And there were all sorts of allegations about wrongdoing there, including claims of sexual abuse, investigations by the police, none of which found there to be any wrongdoing. What the official receiver was saying in the action was that Ms. Batmanghelidjh in particular, I think, created the collapse because of a failure to operate on a proper and financially stable basis. But in fact, when this came to court after 3.5 years, I think quite unusually, the judge threw out the claim really quite unceremoniously. And here are some of the comments. The judge felt that the board had taken steps to ensure it had a plan to manage the challenges it faced. And the judge referred to the unsubstantiated allegations of sexual abuse, which it seems had at least partly led to the failure of the charity. Judge went on to praise the enormous dedication to vulnerable young people over many years by Ms. Batmanghelidjh and her achievement in building the charity, which was widely regarded as highly successful. So high praise, I think. And the judge also went on to praise the 7 trustees, saying most charities would be delighted to have available individuals with the abilities and experience the trustees in this case possess. The judge found that there was no dishonesty, bad faith, or personal gain by any of the trustees. There had in fact been a restructuring plan put in place in association with the government, although ultimately that restructuring plan had failed, but clearly the judge took that into account in making the decision. It's notable that Ms. Batmanghelidjh was not formally appointed as a director or trustee, but she was considered to be what's called a de facto trustee. In other words, by her actions, she took the position of a trustee, and in this case, director of the limited company. And that's fairly clear. We'll come back to that. That's quite an important point, I think. So, pretty unusual to get to this stage in disqualification proceedings and for the court to exonerate the individuals being attacked quite so comprehensively, and indeed going so far as to praise their conduct. It would be really interesting to see a bit more on the background of that. But what are we talking about here? We're talking about directors' disqualification. Now, this is contained in the provisions of the Company Directors Disqualification Act 1986. So it was provisions brought in 1986 to penalise directors whose conduct has fallen far below the standard expected of a director, resulting in the failure of their company. and there are various provisions laid down in the Act, but essentially what the courts are looking for is to penalise gross misconduct. So situations where the conduct of the directors has fallen far below that which would be expected of a competent director, and crucially that there is a public interest in disqualifying directors. And I think probably that is where the official receiver felt there was a public interest, because this was a charity. The nature of the business presumably felt that there was a public interest in taking forward these disqualification proceedings. And an individual can be disqualified from acting as a director for anything from between 2 and 15 years. So what's the process? In every case, if I talk about this from the standpoint of an insolvency practitioner acting as liquidator or administrator of a company, the requirement is, or it was for many years, to file a report on the conduct of the directors with the disqualification unit, part of the Insolvency Service, within the first 6 months of the liquidation or administration, or if, and that could be extended if there was good reason to do so. Although it's considered that should most definitely be the exception rather than the rule. The report would take 2 forms. Firstly, if the liquidator or administrator, the insolvency practitioner, felt there was no unfit conduct to report, he or she simply filed a return with the Insolvency Service, recording who the directors were and saying there was nothing further to report, and that was just put on record that the insolvency practitioner had complied with his obligations. But if the practitioner felt that there had been wrongdoing, then he was required to fill in submit what was called an adverse report, detailing that wrongdoing. What were the matters that he felt should or could result in disqualification? An entirely confidential report, which allows the practitioner to provide information which may be unsubstantiated at that point. That is then for the Insolvency Service to investigate further and take action if they consider it appropriate. And this changed slightly. I think it was in 2016 now. I've lost track of the various changes. So it went from being a written report to an online return, completing a questionnaire. It was an online questionnaire with various questions under separate headings, and depending on the answer to that particular question, that would lead to a drop-down box to provide further information. And then the Insolvency Service will make a decision on whether the conduct reported upon was serious enough to require further investigation. And that took away the onus on the insolvency practitioner really in making a decision on what or wasn't in unfit conduct. And I think there certainly were different approaches. The Insolvency Service always said, look, minor technical breaches aren't on their own sufficient to report adverse conduct. They've got to be a series of breaches and, as I said before, really significant wrongdoing. I suspect there are some practitioners who did report lots of minor breaches, others who maybe ignored more serious breaches when they should have been filing adverse reports. So it's the onus now is on the Insolvency Service and the Directors Disqualification Unit. I think that's right, because they're the people who deal with these cases all the time, and should have a reasonable idea of what is likely to be successful if the case comes to court. It is worth, for people like me who follow these things, it is worth looking periodically at the various disqualifications that have taken place. You can find these on the government website, the Insolvency Service website. There is a section which details disqualifications in the last 3 months. For me, they make quite interesting reading. But I said the period of disqualification is anything from 2 to 15 years. It's pretty unusual to find a disqualification of 2 years, and even more unusual to find one for 15 years. I have just scrolled down the first few from the last 3 months. Shortest, I think, was actually 4 years. It's often 3 years, 3 years, 6 months. Longest, I think, was 12 years. The 12-year one was a director or directors that had been involved in a company involved in what's called the missing trader scheme. So essentially a fraud on the VAT man, where they submit repayment returns for very significant amounts of money. In most instances, usually the company's just been set up to defraud the taxman. So not surprising that would result in a 12-year disqualification, probably on the back of other actions against those directors. But just covering a couple of points. If I look at a 6-year disqualification, a very recent one, which is what the official receiver was asking for Ms. Batmanghelidjh, a person called Yadullah Babakani, hope I've said that correctly, and his company, he failed to ensure adequate records were maintained, or alternatively failed to deliver any records to the liquidator, such that the liquidator was unable to establish whether cash payments out over a period of time of around £500,000 were proper transactions. So presumably the liquidator was able to look at the bank accounts, saw the quite a large number of cash transactions, but the director refused to answer any questions or provide any information or deliver any records which they're required to do, which enabled the liquidator to determine what these represented. The implication being that they were, it was money taken out inappropriately and used inappropriately. So that was a 6-year disqualification. That's not the most serious conduct. The Insolvency Service tends to do these in batches, so lower conduct, adverse conduct, anything up to probably 6 years up to 9 or 10 is middling, and then 10 and above is the most serious conduct. One of these cases, well, there are a couple really, which I'd like to highlight, both 11-year disqualifications. One director of a marketing company, a telephone marketing company, which made 75,000 unsolicited marketing calls to people who had registered with the telephone preference service, which allows you to opt out of receiving those calls. But despite that, continued to make calls in a significant way. I think looking at the report, there have been previous breaches, and so this person was disqualified for 11 years. Pretty severe sanction. That pretty pleased with that personally, having registered for telephone preference services, but still receiving calls. It is worth, it seems, reporting those. And then 2 directors also disqualified for 11 years in a company called Pink Innovations Limited. They were accused of submitting false VAT returns, as a result receiving rebates into the company of £3.5 million. And when the VAT man assessed what the tax position should be, once the company was in liquidation, presumably, there was something like £2.9 million due by the company rather than the £3.5 million rebates. Company also failed to register for PAYE for an extended period, resulting in a final bill due to the taxman of £248,000. So certainly considered to be a public interest there, where the taxman has been disadvantaged. Clearly there's an allegation of fraud here for the false VAT returns, hence the very significant length of the ban. I talked about Ms. Batmanghelidjh being a de facto director or trustee, so not actually appointed. This is important because an individual can be a director by their actions, even though they're not actually appointed or shown as Companies House. And certainly what has happened in the past is that an individual is disqualified, then thinks they'll be clever, get somebody else appointed as a director, quite often a relative, but carries on running the company as if they were still a director. This is certainly taken very seriously. There is a section on the Insolvency Service website where you can report that sort of conduct, and that can lead to fairly severe sanctions against the individuals involved, including the person who allowed themselves to be put in place as a director, but didn't control the business and allowed the disqualified individual to continue to run it. There are circumstances, I should say, where directors who are disqualified can then apply to continue to act as a director of another company. They can make an application to the court, and the court may grant leave to continue where there are extenuating circumstances. So particularly where if this individual had to resign as a director, the company might close, resulting in job losses and potentially loss to people who trade with that company. I would expect the court to impose restrictions on that individual. I think the one case I dealt with where the gentleman was disqualified as a result of his actions in respect of the company over which I was liquidator. He had a sister company. The court granted leave to continue to act as a director, but had to have his accountant, his external accountant, keep very close tabs on the finances of the business. So some safeguards in there. How good are these sanctions? Well, is disqualification serious? Well, it is for somebody who's a businessman and wants to run businesses. It is, as I said, it's there to penalise serious wrongdoing, not there to stultify enterprise or to sanction mere mismanagement. People make mistakes. It's what they do when they've made their mistakes. How they deal with the situation, I think, is important, and certainly the courts do recognise that things go wrong, and it's how wrong are they? How culpable are the individuals in their actions when those things go wrong? There is one final little bugbear I have, which I want to cover. Some years ago, following the BHS failure, Sir Philip Green was put in front of a parliamentary select committee and roundly criticised for his conduct in relation to BHS. And if you recall, the company was failing, not surprising for a retail these days. He was faced with a choice of putting it into administration or selling it to a company controlled by Dominic Chappell, I think you say his name, who bought the business for £1. So look, we've got the expertise to turn this around. We'll buy the whole thing, including the liabilities, for £1. I think the decision for Sir Philip Green was an easy one, really. It means it preserves the money due to the creditors, provided the new company fulfills its promises, over which he had no control. When it came to disqualification proceedings against Mr. Chappell, he was quite indignant and said, well, look, I seem to suggest that he was the innocent party, and everyone knew that Sir Philip Green had been found guilty by this parliamentary select committee, which was not the case at all. They had sat there and had interviewed him. It was very one-sided, in my view. Certainly no counsel for the defence, certainly no court of law. He was very robust in his responses, which amused me greatly. But it did strike me that this was politicians grandstanding and trying to show how clever they are and how important they are, while at the same time, in some cases, showing ignorance of the matters they were questioning, raising questions about. If you do find the report on the disqualification of Mr. Chappell, which I think was quite a number of years, there were some pretty serious allegations there about money being transferred to other businesses, including a significant transfer after the day the decision was made to place the company into administration. So hardly innocent at all, I would suggest. Must have been very frustrating for the Insolvency Service and the Directors Disqualification Unit to have that select committee apparently making findings of wrongdoing without any background information, just by asking questions. It's the unit which is able to investigate in much more detailed manner by looking at the records of the company as well as interviewing the individuals. So that's my take on Kids Company and disqualification. It is a sanction which is important for wrongdoing. Don't always get it right. Clearly, in this case, got it very badly wrong. Pursued what appears to have been an entirely hopeless case, with the targets of the action coming out actually looking very good indeed. So fair play to them. That's all for now. Thank you very much. Let me know if you've got any comments. Bye now.